May it please the court, my lord, on page 14 of the record is the plaintiff's heads of argument, in which the aforementioned statement explicitly sets forth why must all fellow South Africans live and struggle, endeavor, try hard, or go all out, strive, or attempt for freedom in South Africa, their land. The term strive means to struggle, attempt, try, or endeavor. Freedom is like a carrot dangled in front of all of us as slaves. We see it, but we will never have it, even after 28 years of democracy, unless the national anthem changes its terms. President Cyril Ramaphosa, free my countrymen and let them live and enjoy freedom in the universe, our home. The Minister of Defense and Military Veterans has, under Section 62L of the Defense Act 42 of 2002, made the regulations in the schedule, in which the preamble states that whereas the Defense Force is a national asset which is mandated under the Constitution to be structured and managed as a disciplined military force, and in accordance with the principles of international law governing the use of force. And whereas the Defense Force is essential in the defense of the Constitution, the territorial integrity, and national sovereignty of the Republic and our democracy. And whereas the Defense Force provides a soldiering career wherein members entrust their inalienable right to life, which is guaranteed in the Bill of Rights of the Constitution, to the nation and the state. And whereas it is an unavoidable reality that when a soldier is recruited, he and his family becomes a part of a larger Defense Force family as an institution to share in the joys, anxieties, and sometimes unfortunate outcomes of service, including maiming and death. And whereas it is essential for an effective mechanism to be created to provide for the necessary duty of care to the soldier and his or her family, and whereas it is therefore necessary to create a working environment for the soldiering professionals that is positively conducive to discipline, and whereas these factors define the uniqueness of the soldiering profession, and whereas, in line with the uniqueness of the soldiering profession, the Defense Force Service Commission has been duly established in terms of Section 62A1 of the Act as a statutory body. And whereas the Defense Force Service Commission's role will be to provide a comprehensive system of ongoing research, continuous review, investigation, and benchmarking on world-class best practices, in order to provide informed advice to the Minister on all aspects of service conditions for members of the Defense Force, to enable the establishment and maintenance of sustainable condition of high morale and state of combat readiness for the Defense Force. And whereas the fundamental principles that will guide the Defense Force Service Commission in the execution of its mandate will be objectivity, integrity, impartiality, and transparency in conducting its business without bias, fear, or prejudice. And whereas it is necessary to protect the dignity of the Commission in the execution of its functions. And whereas it is necessary to create procedures, structures, and mechanisms whereby the Commission is empowered to fulfill its mandate having regard to the mission, vision, and values of the Commission. Whatever the practice, in former times, a modern code of military discipline cannot depend on arbitrary decision making or the infliction of savage punishments, nor can it depend on inherited habits of difference or gradations of class distinctions. Such a code must of course reflect the hierarchical structure of any army and respect the power of command. But an effective code of military discipline will buttress not only the respect owed to their leaders but by those who are led, but also, and perhaps even more importantly, the respect owed by leaders whom they lead, in which all members of a fighting force owe to each other. This, your worship, my lord, is in terms of Spear versus R and R versus Boyd and R versus Williams in 2002, as outlined in page 252 to page 263 in the Autonomy Stellenbosch Law Review of 2002, issue number 21. The ultimate objective of the military in time of peace is to prepare for war. The military organization to meet this objective requires, as no other system, the highest standard of discipline, which can be defined as an attitude of respect for authority that is developed by leadership, precept, and training. It is a state of mind which leads to a willingness to obey an order no matter how unpleasant the task to be performed. This is not the characteristic of the civilian community. It is the ultimate characteristic of the military organization. My lord, it is the responsibility of those who command and instill discipline in those who they command. In doing so, there must be correction and the punishment of individuals. This is supported by Canadian military criminal law, an examination of military justice, a Chartist Law Journal 23 in page 120 to 123, as cited with approval in the Botsane case and the State versus Tsotsi in 2004 at herein after referred to the Tsotsi judgment, my lord. The Constitution of the Republic of South Africa makes provisions for the defense force that is structured and managed as a disciplined military force. To provide for the continued proper administration of military justice and the maintenance of discipline, to create military courts in order to maintain military discipline and ensure a fair trial and an accused's access to the High Court of South Africa is the objects of the Military Discipline Supplementary Measures Act 16 of 1999, in which the system of criminal justice is based as read with the rules of procedure and the Military Discipline Code. The South African military law has been to ensure discipline in the military, and the military court system has been recognized by the Constitutional Court. Paramount importance to the upper guardian of the children's rights. In V versus V on 1998, Fox Crawford J. at paragraph 189 puts forward that part of the difficulty with this question is that in a custody case, one is only indirectly dealing with the parent's rights. The child's rights are paramount and need to be protected, and situations may well arise where the best interest of the child requires that action is taken for the benefit of the child, which effectively cuts across the parent's right. Although access rights are often spoken of as a right of the child, it is artificial to treat them as being exclusive of the parent's rights. To my mind, the rights which a child has to have access is to its parent is complemented by the right of the parent to have access to the child. It is essential that a proper two-way process occurs so that the child may fully benefit from its relationship with its parent in the future. Access is therefore not a unilateral exercise of a right by the child, but part of continuing relationship between parent and child. The more extensive that relationship with both parents, the greater the benefit to the children is likely to be. My Lord, the background of this matter stems from in an event any person does not understand the terms country and its people. There is no way such a person may determine this matter in accordance with the Constitution and the law. As this matter is for the country and its people being served and defended by the plaintiff in accordance with the Constitution and the law. The plaintiff moves in terms of Section 1995 of the Constitution and begs the indulgence of the court to a dispute that can be resolved by the application of law decided in a fair public hearing. In an urgent action for a declaratory order in terms of the notice of motion on crimes against the state and the administration of justice, in which the defendants are called to defend a charge of high treason, wherein as persons owing allegiance to the Republic of South Africa unlawfully and intentionally engaged in conduct with the intention of violating, threatening or endangering the existence, independence or security of the Republic, or changing the constitutional structure of the Republic, and unlawfully or intentionally coercing the government of the Republic of South Africa into refraining from any action in relation to the plaintiff, and subsequently torturing, enslaving, or subjecting him to cruel, inhumane, degrading treatment or punishment inter alia crimes against the dignity and reputation. My Lord, people in the universe, the Republic of South Africa, and the entire South African National Defence Force are coerced to firmly believe that an unlawful and intentional false entry in the DoD PESOL system on 8 August 2018 and 9 days later on 17 August 2018, writing a letter to be delivered in the middle of the following week to Lieutenant Commander Sylvester Vulani Mangolele, is the lawful procedure for termination of service of members of the regular force. It is argued that this is an absolute miscarriage of the founding values of the first defendant relative to the supremacy of the Constitution and the rule of law. And when considering the Constitution, the court's indulgence is directed to the provisions of Section 23(1) of the Constitution, which reads that everyone has the right to fair labor practices. When an erudite court reads these provisions with the obligations imposed in terms of Section 1995 of the Constitution, it will understand the gross violation of the Constitution by all defendants. And in relation to the law, Section 59(1)(d) of the Defense of Act number 42 of 2002, hereinafter referred to as the Defense Act, imposes an obligation that the services of a member of the regular force is terminated if he or she is sentenced to a term of imprisonment by a competent civilian court without the option of a fine, or if a sentence involving a discharge or dismissal is imposed upon him or her under the code. My Lord, all defendants must satisfy the court only on the argument supra and prove beyond any reasonable doubt that as persons owing allegiance to the Republic, their conduct, act or omission was not unlawful and intentional. It is tried that all defendants are subject to Chapter 11 of the Constitution as security services, who must act and must teach and must require their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic. And in any event, only the President may cancel a permanent commission of the plaintiff. It is submitted that the process embarked on by the defendants to unlawfully and intentionally deprive the plaintiff his salary for the past 36 months is unconstitutional, unlawful, and invalid, and the defendants are put to prove its validity. My Lord, the urgency of this matter is the primary fact that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled for all people in the country that the plaintiff serves and defends with honor, dignity, courage, and integrity. Given the all-encompassing nature of the matter as defined in terms of Section 198 of the Constitution, and the event in which the Bill of Rights is betrayed by those employed to uphold, defend, and respect the Constitution as the supreme law of the Republic, and promote the unity of the nation and that which will advance our Republic and its people, the court may not further prejudice the plaintiff as a result of the inefficiencies or personal preferences of the members of the criminal justice system, which is intentionally and unlawfully employed by persons in critical capabilities of state, which is the first defendant in this matter, my Lord. The dispute arises from the lawfulness of the administration of the plaintiff's employment contract by the defendants who, antithetical to the Code of Conduct for uniform members of the South African National Defence Force, did not respect and support the plaintiff as a subordinate and treat him fairly. The defendants are called to show cause in relation thereto, my Lord. In terms of the locus standi, the plaintiff approaches this competent court as a result of his rights enshrined in the Bill of Rights having been threatened or infringed, and prays to the Honorable Court to grant appropriate relief, including a declaration of rights. My Lord, the plaintiff is not only acting in his own interest, but that of his children, family, country, and its people, in the public interest, including in the interest of the members of the South African National Defence Force, and in defence and protection of the Constitution, the territorial integrity and national sovereignty of the Republic, and our democracy, against all enemies, foreign and domestic. When interpreting this matter, my Lord, persons entrusted with constitutional duties must do so relative to the fact that there is no prison without a roof, as I am currently subjected to, which is homelessness, and promote the values, the spirit, purport, and objects that underlie an open and democratic society based on human dignity, equality, and freedom enshrined in the Bill of Rights. It must consider international law and may consider foreign law. The guiding light for interpreting statute is Section 39(2) of the Constitution, which requires that all persons interpreting any legislation must promote the spirit, purport, and objects of the Bill of Rights. As the Constitutional Court put it in Makate vs. Vodacom, Section 39(2) means that the courts are bound to read the legislative provision through the prism of the Constitution. There is no way one cannot consider the following. First, where a provision is capable of more than one meaning, Section 39(2) creates two obligations. The first obligation might conveniently be referred to as the Hyundai obligation. If a provision is reasonably capable of two interpretations, and one interpretation would render it unconstitutional and the other not, as is the case on this matter, considering the paramount importance of the best interest of the child, who must be protected from maltreatment, neglect, abuse, or degradation, the court is required to adopt the interpretation that would render the provision compatible with the Constitution. Thus, in Hyundai, the Constitutional Court held that judicial officers must prefer interpretation of legislations that falls within constitutional bounds over those that do not, provided that such an interpretation can be reasonably ascribed to the section. The second obligation might conveniently be referred to the Wari obligation, my Lord. If a provision is reasonably capable of two interpretations, Section 39(2) requires the adoption of the interpretation that better promotes the spirit, purport, and objects of the Bill of Rights. This is so, even if neither interpretation would render the provision unconstitutional, my Lord. And this is at paragraph 46, 84, and 107 of the Wari Holdings versus Staulwa Property Limited, and another that was heard by the Constitutional Court in 2009, my lord. Second, Section 39(2) is not a license to ignore the text of legislation. The legislation must be reasonably capable of bearing the assigned interpretation, or as such, J put it in SAPS versus PSA. Section 39(2) requires that the language used be interpreted as far as possible and without undue strain so as to favor compliance with the Constitution. It is not only textual tension that must be avoided, but only undue strain. Third, my lord, at the same time, Section 39(2) specifically, and the Constitution as a whole, embraces a new approach to interpretation. It requires courts to prefer a generous construction over a merely textual or linguistic one in order to afford claimants the fullest possible protection of their constitutional guarantees. This is as held in the Department of Land Affairs and others, and versus Googling tropical fruits that was heard by the Constitutional Court in 2007 at paragraph 53. Then these are my emphasis, my lord, when one has to bring into light the concept of interpretation and interpreting what counsel is leading in the record of court. International law plays a vital role in interpreting statutes for two reasons. Section 233 of the Constitution provides, when interpreting any legislation, every court must prefer any reasonable interpretation of the legislation that is consistent with international law over any alternative interpretation that is inconsistent with international law. This is cemented by the terms of Section 39(1)(b) of the Constitution, my lord, which binds the court to consider international law when interpreting the Bill of Rights. And international law is relevant to determining what those rights, including the rights to security of tenure, property, culture, and a healthy environment, demand. The issues for the library of this particular court are as follows. At the crux of this matter, law permitting arbitrary deprivation of property by placing the plaintiff's personal belonging on the streets without alternative accommodation, homelessness. That is at the fundamental crux of this particular matter. The plaintiff is homeless. The plaintiff is without a constitutional address. Damage or loss suffered as a result of an act or omission arising from any training or service under the Constitution and the law, whether or not legal proceedings have been or are to be instituted, past and future loss of income. The other issue, my lord, is torture, cruel, inhumane, or degrading treatment or punishment, which is pain and suffering. The other issue, my lord, is slavery, servitude, and forced labor, constantly being forced to spend sleepless nights drafting correspondences in sort of inalienable rights, freedom, and peace. My lord, the South African Defence Review 2014 is extensively discussed in the founding affidavit. And what the court must ask is whether outcome statement 1 of the strategy employed is achieved in the following sense. Are the comprehensive capabilities enhanced and maintained when considering the plaintiff as the said comprehensive capability? Is peace, stability, and security in the Republic of South Africa, region, continent, and world promoted having regard of the plaintiff? Are the people of South Africa supported taking into consideration the plaintiff, his children, family, friends, and community? The other issue, my lord, is the national anthem enslaves the entire nation in prayer, compelling God to answer by allowing each person to live and struggle for freedom in their own land. It is only a slave who lives and strives for freedom in their land, not a free democratic republic with a world-class constitution such as the Republic of South Africa. The court must ask, why must we live and struggle for freedom after 27 years of presumed freedom? Do we not have freedom if we are forced to pray not to have freedom, but struggle or attempt for it? Why must we not live and enjoy freedom in the universe, our home? The other issue is to amicably resolve this matter in the interest of justice and for generations to come, having regard of law, of precedence and purpose. The court must apply, or if necessary, develop the common law to the extent that legislation does not give effect to that right, and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by that right when applying the Bill of Rights to the plaintiff as a natural or juristic person. My lord, the other issue is having regard of the constitutional obligation imposed in terms of Section 25(6) of the Constitution. The plaintiffs entitled to tenure which is legally secure or to comparable redress. The first issue is simply solved by the address on the letter dated 17 August 2018. And comparable redress will be dealt with in the military court. It is therefore submitted that the plaintiff's address is interlocutory and it cannot be disputed or changed or appealed, and in any event no argument will change the address inscribed on the letter dated 17 August 2018 to the plaintiff by the fourth defendant will change its terms from number 4 Cable Hill Road, Simonstown 7975. My lord, in Daniels vs. Scribante, the Constitutional Court emphasized that the courts must adopt a purposive interpretation that is compatible with the mischief being addressed by the statute concerned. That means that a court must determine the goal of a statute as a whole and of a particular provision and seek, as far as possible, to interpret the legislation to further that goal. In the specific context of Section 25(6), the court held, with all this background in mind, the mischief that Section 25(6) of the Constitution and the ESTA are seeking to address is not far to seek, Addressing that mischief is not only about securing the tenure of ESTA occupiers. It is also about affording occupiers the dignity that eluded most of them throughout the colonial and apartheid regimes. We must adopt an interpretation that best advances this noble purpose of Section 25(6) and ESTA. The other issue, my lord, is that, having regard of the supremacy of the Constitution and the rule of law, and the all-encompassing nature of the plaintiff's right to life, Section 172 of the Constitution imposes an obligation for a court to declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency, and make any order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity and an order suspending the declaration of invalidity for any period and on any conditions, to allow the competent authority to correct the defect. The President must cancel a permanent commission of the 4th and 5th defendants and remove from office the 3rd, 6th, and 7th defendants for crimes against the state and the administration of justice in order to resolve the second issue advanced. In context, it is trite that most words can bear several different meanings or shades of meaning, and to try to ascertain their meaning in the abstract, divorced from the broad context of their use, is an unhelpful exercise. Or as Louis A.J. pithily put it, that words without context mean nothing. The obligation to consider context is required by the Constitution. Context, as Moseneke, Deputy Chief Justice, explained, includes two elements: the social and historical background of the legislation and the grid or related provisions of the statute as a whole, including its underlying values. The plaintiff's unique circumstances must be interpreted against the historical background of devaluing customary rights and freedoms. My lord, this matter is as is. The terms before this court and this particular record are as they are. One cannot run away from the issues that Act number 13 of 2013, Prevention of Combating and Torture of Persons Act, gives effect to the Republic's obligations in terms of the United Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment, provides for the offense of torture of persons and other offenses associated with the torture of persons, and prevents and combats the torture of persons. It is tried that the first defendant has a duty to promote awareness of the prohibition against torture aimed at the prevention and combating of torture. That is as obligated in terms of Section 9(1) of Act number 13 of 2013. Having to draw reference in terms of Section 3A, 2 and 3 of Act number 13 of 2013, relevant to this matter. Torture means any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on Lieutenant Commander Sylvester Vulani Mangolele for such purposes as to punish him for an act committed by Mr. Marcel de Vet on 8 August 2018 and the letter dated 17 August 2018 by Vice Admiral Samuel Hlongwane, or intimidating or coercing the plaintiff to refrain from serving and defending the country and its people in accordance with the Constitution and the law. The court is called to consider the presence of aggravating circumstances and without excluding other relevant factors that the following factors must be taken into account. The defendants have discriminated against the plaintiff. The defendants have inflicted serious mental or physical harm to the plaintiff. The conditions in which the plaintiff is currently detained are barbaric, as there is no prison without a roof, being homeless. The role of the plaintiff is such that he did not damage any property in any of the premises of the first defendant and is subject to false allegations of trespassing which resulted on unlawful detention of the plaintiff in Pollsmoor for 44 days at the time before the malicious prosecution that occurred on 21 January to 28 June leading to these particular proceedings, my lord. It is argued that an offence of trespassing is a Schedule 1 non-arrestable offence in the accused, and the accused cannot be detained while awaiting trial. Therefore, what the plaintiff is up against is not constitutional will, but the will of the people abusing their power and influence to intimidate the plaintiff. My lord must also consider or take into account the severe pain or suffering of the plaintiff as a parent being forced not to care and contact his beloved children. The Law Dictionary featuring Black's Law Dictionary, free online legal dictionary, 2nd edition, defines a slave as a person who is wholly subject to the will of another, one who has no freedom of action, but whose person and services are wholly under the control of another, one who is under the power of a master and who belongs to him, so that the master may sell and dispose of his person, of his industry and his labor without his being able to do anything, have anything, or acquire anything but what belongs to his master. It is submitted that the plaintiff feels like Dred Scott, whose citizenship was denied by the U.S. Supreme Court on 6 March in 1857, and therefore not entitled to freedom. The Forced Labor Convention, 1930, number 29, and the Slavery Convention, 1926, were drafted in the same time period and should be read in tandem for understanding how related concepts of slavery and forced labor were viewed. Later instruments, particularly the International Covenant on Civil and Political Rights, ICCPR, 1966, and the European Convention on Human Rights in 1950, modeled their prohibition on forced labor and slavery on these earlier definitions. The European Court of Human Rights, acknowledging the reliance of European Convention drafters as a guide. That particular guide is Van der Mosel versus Belgium, application number 8919 of 1980 at paragraph 32. Similarly, the Human Rights Committee, the treaty body that monitors implementation of the ICCPR, has noted that the ILO definition are relevant in elucidating the meaning of the terms forced and compulsory labor. There is no way that one may deal with the third and fourth issue without consideration Articles 4 and 5 of the Universal Declaration of Human Rights, mandating that no one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all their forms, and no one shall be subjected to torture or to cruel, inhumane, or degrading treatment or punishment. Section 12(1) and 13 of the Constitution mandates that everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily or without just cause, detained without trial, free from all forms of violence from the either public or private sources, not to be tortured in any way, and not to be treated or punished in a cruel, inhumane, or degrading way, and that no one may be subjected into slavery, servitude, or forced labor. Section 4 of the Prevention of Combating and Torture of Persons Act provides that any person who commits torture, attempts to commit torture, or incites, instigates, commands, or procures any person to commit torture is guilty of the offense of torture. Is guilty of the offense of torture, and on conviction liable to imprisonment, including imprisonment for life. It is further provided for that despite any other law to the contrary, including customary international law, the fact that the defendants are a head of state or government, a member of government or parliament, an elected representative or a government official, or was under a legal obligation to obey a manifestly unlawful order of government superior, is neither a defense to a charge of committing an offense of torture, nor a ground for any possible reduction of sentence once that person has been convicted of such offense. As equal persons before the law, the defendants must go to jail for life. My Lord, the urgency of this matter is an all-encompassing national security condition in which, as a citizen of South Africa and a volunteer in the South African National Defence Force, the undersigned is homeless. tortured, enslaved, live without freedom, peace, and safety. The plaintiff, my lord, is unable to participate fully in the process of democratic governance. Lieutenant Commander Sylvester Mangolele is deprived enjoyment to protection of fundamental rights, including unlawful and intentional denial of his parental responsibilities and rights. Lieutenant Commander Sylvester Vulani Mangolele is without access to resources and the basic necessities of life. The plaintiff is inhabiting an environment which is detrimental to his health, well-being, and bodily integrity. The plaintiff is arbitrarily or without just cause deprived of his salary since 8 August 2018. The plaintiff is presumed guilty until proven innocent, and the plaintiff is unlawfully and intentionally deprived security of land and tenure to number 4 Cable Hill Road, Simonstown, 7975, and comparable redress. My lord, the plaintiff submits that he would not be able to receive redress if the application is only to be heard in due course, as he is impecunious, without health care services, including reproductive health care, without food and water, and social security, including social assistance, as he is unable to support himself and his dependents. The plaintiff has dependents, which includes children whose best interests are of paramount importance in every matter concerning them, and thus far the courts, in fear of the influence of the second defendant, which is the president, have been trying to force the plaintiff to believe that he has no parental responsibilities and rights, so as to try and protect the defendants while subjecting the plaintiff into slavery, servitude, forced labor, by continuously trying to find ways to make the plaintiff not come back to court and misleading the plaintiff that his matter is not urgent, which means that the plaintiff must continue to be without his fundamental human rights and wait for the unopposed or opposed motion roll, whose first available dates defeats the reality and the supremacy of the Constitution and the rule of law. My lord, to be frank, and given the numerous attempts by the plaintiff to come to court in sort of his inalienable rights and employment contract, which the judiciary has by instruction of the corrupt officials to torture the plaintiff, ensured in any event that every rule of court, including Rule 39(1) of the Uniform Rules of Court, is deliberately ignored, violated, or intentionally omitted, so as to continue to protect the defendants from accountability. My lord, the urgency of this matter is long overdue by 28 months at the time of the plaintiffs having to beg the people for their own money to survive, while the defendants are living comfortably with impunity, albeit it is true and correct that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. It is submitted that the plaintiff is on duty 24/7, my lord, as a juristic person who is entitled to the rights in the Bill of Rights, to the extent required by the nature of the rights and the nature of the juristic person mandated by an Act of Parliament to arrest the decline in critical capabilities through immediate directed interventions in terms of the South African Defence Review 2014. And in any event, my lord, immediate directed interventions is an urgent action. In conclusion, my lord, the plaintiff endured irreparable harm to his dignity as a person and a loyal servant to the people of the Republic of South Africa, and sought for an interlocutory order in terms of the notice of motion pending the conclusion of the matter before the Magistrate Court of Simonstown to case number A686 of 20, A718 of 20, and M503 of 20. Without any proof relative to the process and procedures followed in terms of Section 59(1) of the Defence Act, no authority may come to a lawful conclusion that the plaintiff is without employment, or may refer to the applicant as was employed. The plaintiff is employed by the South African National Defence Force and is arbitrarily or without just cause deprived of income since 8 August 2018 to date. My lord, the plaintiff prays to the court to grant a just and equitable order and enforce his employment contract. My lord, since the plaintiff is denied access to all South African National Defence Force premises and has lost all his personal belongings, the fourth defendant is to file the plaintiff's employment contract with the registrar and serve a copy to the plaintiff via email. In the premises, the plaintiff prays that the court upholds the rule of law and holds true the primary fact that everyone has the right to fair labor practice, and make an order that is just and equitable to that effect. And in any event, the bail condition of the Simonstown Magistrate Court is inconsistent with the provisions of Section 21 of the Constitution. Therefore, invalid, unlawful, and unconstitutional. And the court must set it aside and fulfill the obligations imposed for the plaintiff to enjoy freedom of movement and residence in the universe, our home. My lord, this concludes the heads of argument that were to be heard on 5th of January 2021. Following this particular application, it was then an opportunity for the respondent to respond, and the respondent did respond. And I would like to ask for a short adjournment for His Lordship to be given the response of the defendants, and also to take a small break and then refresh the body. May it please the court to grant a short adjournment in the interest of justice, my lord. The interest of justice demands the nature is calling, and when the nature is calling, one needs to answer the call as it pleases the court, my lord.